On the JDC side, or the juvenile facility side, the question was more about security and the cultural concerns around that. And Steve Thomas really puts it well, the administrative director of the Pierce County JDC, when he says, "I wish they were doing more for those kids at that jail, but I can't safely have them here. I don't want those kids around these kids." And his differentiation really shows shows the big difference in jail administrators' thinking. Right now at JDCs, they don't have guards, they have staff. And these staff don't carry tasers, they don't carry pepper spray, there are not a lot of physical extractions that need to happen or many physical confrontations. A lot of the JDC administrators felt that if you were to house the declined juveniles in a JDC or a juvenile facility, that a lot of this would have to change. They'd have to add more isolation units to keep some juveniles misbehaved. They might have to start arming their staff in order to protect themselves and protect their inmates. And they thought that some of their methods, such as talking out of problems, talking about, how did you feel that made you act out, wouldn't necessarily happen if you had the other juveniles who pose the bigger security threat within the JDC. So to sum up, there are, again, no easy answers when it comes to management. Also, something that's very significant is what happens to these inmates or juveniles after they leave the jail or the JDC. And Inwu will talk about that in our next slide.
So there are other extending consequences that deserve consideration for juveniles having spent time in an adult jail. The first difference is in the sorts of reentry programs that are offered to these juveniles. Since, as Lauren noted earlier, a majority of Spokane's juveniles did end up serving their sentence in jail. This is especially important. When visiting the King County Regional Justice Center, we found that there is no sort of reentry program offered to inmates. In fact, they're let out the door on the day of their release. JDCs, in contrast, attempt to offer various forms of services and programs to help inmates after they're released, which varies by county. One example was Island County JDC, and they actually maintain a transitional specialist on staff who, amongst other things, oversees the juveniles' reentry into school and also ensures that educational credit is earned for school time completed at the JDC. This was an especially interesting JDC that we got the opportunity to learn more about, and it can be found on page 21, deeper overview of that JDC. Second, recidivism is an important indicator of each facility's capabilities and effectiveness to rehabilitate these juveniles. Through our research, we found very little data on tracking recidivism rates of juveniles released from jail versus JDC. We even found national statistics to be conflicting. However, studies done by the Task Force on Community Preventative Services found that juveniles transferred to the adult system are 34% more likely to recidivate than those kept in the juvenile justice system. No definite conclusions, however, can be drawn from our data regarding the recidivism rates of juveniles released from jail and JDC, but this is definitely an area that deserves future studies. Lastly, it is important to consider the other sorts of barriers these youth face upon re-entering society, especially in terms of accessing employment. When you're a juvenile that is declined to the adult system, you also maintain an adult criminal record. This begs the question what sorts of collateral consequences are associated with an adult record for these juveniles. First, we found that in practice, there's very little difference between a juvenile and adult record in terms of employment. Employers tend to see both records similarly in making their hiring decisions. One notable difference, however, is in the sealing procedure of both sorts of records. There's no easy way for an adult record to be sealed. Sealing would mean that the juvenile could, one, claim that they legally have a clear record, and two, that these records would be closed from any future public accessibility. Though we recognize the effectiveness of sealing is ambiguous, partly because third parties tend to get a hold of these records prior to sealing and distribute them over the internet for a profit, the potential benefits of sealing shouldn't be undermined. Thus, the collateral consequences associated with an adult record for these declined juveniles may be especially large, and this presents difficulties in their ability to access future employment opportunities that may more permanently follow them throughout their lives, and challenges that deserve serious consideration.
So, after 6 months of research, our group has several recommendations to improve the current system. In this presentation, we're only going to emphasize the most significant recommendations. However, we encourage you to look at our complete list of recommendations, which is in the report on page 27. Our recommendations are divided into two parts. The first section works within existing state law, and the second section contains recommendations if Washington state law could be amended. Ultimately, our recommendations are centered on a goal to house each juvenile in a facility that best suits their needs. So first, zooming in on working within state laws. Our first recommendation is that there needs to be a central database that tracks declined youth from charge to release. And by this we mean to keep all the information in one area so that it's easier to keep track of how many youths are in the criminal justice system as well as where they're being detained. In addition, having one uniform policy would increase the uniformity among the different counties and keep them accountable to the numbers that they actually report. Secondly, if juveniles are transferred to jail, we recommend that we keep them in general population. Although it seems counterintuitive to place a juvenile in a jail with adult inmates, this recommendation stems from overwhelming consensus that we got from interviewing the 14 auto-declined youth at Green Hill. We felt that integrating the youth in general population would be more beneficial and appropriate rather than what often happens, which is keeping them in isolation. Green Hill inmates also reported having positive experiences while in the general population while, as we said before, being mentored by adult inmates. In addition, all 14 Green Hill inmates claimed that they all had difficulties with isolation. So now we're going to move on to our recommendations if Washington state law could be amended. And our first policy recommendation is that there needs to be a uniform housing policy across Washington state. These statewide housing policies should address, but should not be limited to, sight and sound separation, programming and educational services, as well as housing policies and conditions. Recognizing that each county is different, this should be based on each county's capabilities and resources. Next, we'd like there to be a transfer policy from jails to JRA post-sentencing. Earlier, one significant finding we discovered was that in Spokane County, 71% of juveniles in jail remain in jail after sentencing, compared to only the 15% who moved to a JRA facility. The current policy is that if a juvenile is sentenced to more than 1 year, they go to prison and the Department of Correction transfers them to a JRA. However, we suggest that jails should do the same and transfer juveniles to JRA who are sentenced to more than 90 days in a jail. And this is because jails are not built to house juveniles long-term. And in a JRA, auto-defined youth would have more access to educational services and programs. And we chose 90 days because Pierce County officials suggested that youth benefit from being close to their families, especially in the first several months of incarceration. Our next policy recommendation is twofold. We're recommending that we only auto-decline charges for crimes such as murder and homicide. And this recommendation is based off of our interviews with King County judges, defense attorneys, and even some prosecutors who suggested that auto-decline charges should be limited in some capacity. In cases of rape, assault, and robbery, our group recommends that discretion decline hearings be held. By holding these hearings, the facts of the case can be weighed on an individual basis, and our group believes that this will both ensure justice for youth and limit the number of auto declines in Washington state. If this recommendation cannot be implemented, at the very least, we believe that robbery 1 should be removed as a charge that gets auto declined. This is because we believe that the severity of the crime does not justify a juvenile's transfer to adult court, because juveniles are more suited for the juvenile system and should thus remain there. We believe that youth charged with robbery 1 do not pose a significant management problem for juvenile detention facilities, unlike those juveniles who have been charged with more severe crimes such as murder and homicide. This recommendation would result in decreased racial disproportionality of declined juveniles, as black youth are disproportionately charged with robbery 1. And finally, this would result in a decrease of juveniles that get auto declined, since 47% of juveniles in jail are also charged with robbery 1.
Juvenile offenders clearly represent a difficult and complex challenge for the criminal justice system. And this is because while they're legally defined as adults, they're still vulnerable youth. And this ambiguity leads to a variety of management, security, and philosophical issues. And while there's no perfect solution as to where to house juveniles, we hope that our findings serve as a step in the right direction for further policy changes, as well as for further research. And I also want to acknowledge all of the people that helped us throughout our research endeavors. I know that I speak for the entire group when I say how impressed we were that people were willing to aid us throughout our entire experience. And we especially want to thank Professor Steve Herbert for his constant guidance and support over the last 6 months, as well as Melissa Lee and Columbia Legal Services for giving us this opportunity.